Welcome back, everybody. This is Michael Liveris from jurisq.com, where we bring you different attorneys, different practice areas who can educate us on the law. And today we welcome back Dan Minc, a partner in a premier law firm in Manhattan, does personal injury all over New York City, New York State, Rosenberg, Minc, Falkoff, and Wolff. Mr. Minc, welcome back.
How are you, Michael? Glad to be here. So wonderful to talk to you about these important questions about the law.
Thank you. And we thank you for your time. And because you do so much litigation, you actually go to court to fight for your clients. We wanted to bring law to life. You told me off camera, there's a technique that experienced, seasoned attorneys use in courts. It's called high-low. It is used when you are facing a difficult case, a determined opponent. What is high-low? I never heard of it. Can you please explain?
Well, Michael, it's interesting because we try the difficult cases, okay? We will fight for a client, and sometimes you realize it's an uphill battle. It's a difficult fight, but you're not going to lose the fight. You don't want to lose the fight.
No.
If you lose the fight, your client gets nothing. That's not. We don't like that scenario. We don't. You know, our clients get money, and so one of the techniques that sometimes you have to employ is called a high-low. So what's a high-low? It's an industry term. It's a term we use. It's a gambling term, right? A high-low.
Okay.
You're hedging your bets on behalf of your client. You're going, okay, I have a case. It's a difficult case. The jury could find against me. The jury could find partially against me. I think I'm doing a good job. I think I'm persuading the jury, but I don't control them. I'm not in the jury room. Okay. So I propose on a difficult case, a high-low. A high-low means you set boundaries, limits for the maximum you can win, but also for getting a minimum guaranteed. So you're guaranteed a win with a high-low. Okay, you're guaranteed a win. You're giving up, but you're getting.
Okay.
So sometimes you'll have a client. They've been injured for a long time. They have debts. They have family. They need money. They really haven't worked in a long time. So they have everything on the line. You're fighting for their economic life. And, you know, it's not a perfect scenario. The law could be difficult in the case. The judge could be a very biased individual that you're having trouble with because they used to be a prosecutor, or they used to be a defense lawyer, or they politically antagonistic. They just don't like your client, or maybe they don't like the lawyer. Okay, you know, when you fight, you know, it's not always pretty. I mean, a judge makes a bad ruling for your client. You got to fight him. There are things you have to do. You have to put it on the record. Judges don't like that. You have to make a statement. You have to make a stand. You have to try and demonstrate to the jury, hey, this is bias. This is not right. You have to overrun. You have to overturn. You have to do what you got to do to create justice here. So a lot of times you're battling for your client, and you have to step on toes. You know, you have to break some glass, right? Judges aren't always interested in your case or your client. They might not like your client. So you can propose a high-low.
Okay.
What does the high-low mean?
Yeah.
Go to your client. Look, if we win this case, all in, the higher court has had similar cases. The maximum recorded is $2 million on a case like this. Okay. Even if you got $6 million from the jury, it's likely that the court would limit it to $2 million.
I see.
That happens every day in New York. You get a verdict, you get a good verdict, and the other side goes to a higher court and says, look, verdict's too high. It's not, it what they call shocks the conscience of the court.
I see.
It's out of the norm, out of the bounds. So a win isn't necessarily a win. I get a win, I get $8 million. I say to the client, look, calm down. Okay, it's step one.
Mm-hmm.
They're going to appeal this. They're going to appeal it as too much. We have to fight that. Or maybe we can get it resolved now. Maybe we can settle it. I have examples of this that have worked both ways. But a high-low, both while you're trying the case, oftentimes at any point in the trial, could be right before you start, because you know some damaging evidence is going to come in, and it's not going to be pretty, and you're going to have to hold your nose and move forward, okay? But you can win, or you can lose, right? Or you could partially win. So there's a lot of different options. So you say to your client, look, give me permission to at least get you a guarantee of some money when you walk out of here. So cases worth $2 million. Look, you got a 50-50 chance of losing. All right, I have to be realistic. I mean, I'm going to fight for you, but I can't control the minds of this jury. And as you know, if you're, for instance, a Democrat and you give a speech at a Republican convention, right?
Okay.
Anybody care how
I could get ugly real fast.
Does anybody care how good your speech is? No. Okay, because it's the wrong audience, right? So they'll listen, maybe politely, maybe not, but they're not going to vote for you. They're not going to say, wow, that's an interesting person. They might smile and vote against you. Okay?
Right.
Same thing in a jury trial. Same thing. If you have people with unconscious bias, and it happens all the time, unconscious bias, they sit down and they say, oh, I can be fair, but you know that it's a police officer. All right? So how are you going to fight in a police abuse case with a police officer on the jury? It's unconscious bias. You can't overcome it. If you have a doctor on the jury, a doctor's wife on the jury, how are you going to present the medical malpractice case and think that they don't have unconscious bias? Okay? So you propose a high-low. A high-low means, look, you're going to have to give up on the max. You're going to have to agree to the judge, binding, that even though my case could be worth $2 million, I'm going to take $1.5 million. Even if I got $2 million, even if I got $6 million, you owe me $1.5 million, no questions asked, no appeal. When this jury renders a verdict, if it's more than $1.5 million, it doesn't matter. You're writing me a check for $1.5 million. But on the low end, you're promising me, guaranteeing me $750,000. Okay? I don't care if I lose. I don't care if it's 50-50. I don't care what it is. I don't care if the jury comes in with $300,000. You owe me $750, no appeal, no questions asked. So you're setting boundaries. Okay?
Yep.
On the low, the insurance company's not happy. They may have to pay $750 on a case they could win. Right? They may owe $750,000. That's painful for them to write a check to me.
Of course.
After, and it's happened, okay, after they won the case.
Dan,
on the other hand,
this is very interesting, Dan. Thank you so much for explaining it and bringing it in, because you explained the concept in very useful terms and that are easy to understand for a layperson, for somebody who's not an attorney. And this is what we do here, is we educate the public. As a matter of fact, you explained so well. I can see you being a professor in law school, and I can see you being a legal analyst on CNN or Fox News, whatever the preference is. So we appreciate it.
These are concepts that experienced attorneys employ. Okay, I'm going to use every technique. I'm going to pull every arrow out. Okay, whether they're poison arrows or deadly arrows or wounding arrows. Okay, I have to fight and use every skill.
And you have a lot of arsenal, and the biggest tool in your toolbox is your experience, because you have seen it all. You've seen, like you said, that you have to pre-envision how even a win is not necessarily a win, because like you said, you can win $8 million, but then at an appeal, it's going to be struck down to much lower numbers. So may as well possibly agree to get less now, but it takes guidance of an experienced attorney to lead the way for the client. And of course, the client is the one who has to make a decision, right? Then,
So Michael, you know what the
ultimately,
problem with I've told you what the usefulness of a high-low is. What is the negative of a high-low?
Okay. Yeah.
What if I get 6 million on a $2 million high-low, right? The client is going to turn to me at the conclusion of the case and say, you SOB, okay? You told me to take a high-low and cap it at $2 million.
Right.
And I got you got me 6 million. I did too good a job. Okay. I did too good a job. But what they don't understand is the 6 in New York State is not necessarily 6.
Right. Exactly.
Okay.
It's making
There
an
could be
educated
an
guess,
error.
educated bet, right? An
There's
educated
something called the appellate court. Okay.
Right.
And if you get hit with a $6 million judgment, I've won many cases and they take them up. Okay. And they say the judge made a mistake, the judge made an error, shouldn't allow this evidence, shouldn't allow that evidence, the number's too high, their witness was this. So there's many pitfalls. It's called a settlement. It's another way to settle a case. You know what they say? You can't appeal a settlement.
Exactly. That's a good point.
So,
Dan, by the way, speaking of appeals, I think appeals is a very interesting topic. Not everybody understands that a win is not necessarily a win, or even a loss. You could also possibly appeal. So at some point in our discussions, I want to come back to it and have a whole session on how appeals work. But for now, I think we have enough very useful information.
We just won an appeal that a judge threw out our case. Okay, he threw it out. He threw it out on a motion. And we had to go to the second department to appeal the case, to overturn the stupid judge. This was ridiculous, but they threw it out.
Yep.
Now, it cost us a lot of money, cost the client a year and a half of waiting.
Wow.
A lot of effort, the appellate work. So it's a whole nother story.
Absolutely. Yeah. I
Anyway,
definitely want to talk about it.
A high-low
is
a technique, and it's a good one.
Yep, absolutely. Thank you for sharing the technique with us. Thank you in general, Dan, for educating our viewers, because it's very important to get general information about personal injury law in New York. But if anybody has any specific questions about your case, you unfortunately were just in an accident, maybe even a few months ago or just now, it is important to call an attorney like Dan Minc to get free consultation and see what you may be possibly entitled to. The phone number is on the bottom of the screen. Please feel free to call. Dan, thank you. Thank you for everybody for tuning in. And in our next session, we spoke just now about litigation. We actually going to have a special guest, your partner, who is actually right now in the middle of a trial, and he's going to give us some insight as to what's happening in the trenches of personal injury litigation right now. I think it's very interesting. He's coming from the battle. We're going to have him shortly.
I'm going to bring Gary Silverstein in. He's a very skilled, experienced trial lawyer, partner of mine. He's in the middle of a trial right now. He's got a day off with the court, and it's some interesting. You can learn something from his preparation and his skill. He's going to talk about it. Thank you.
Perfect. Thank you.